So we can start now.
Yeah, go ahead, please start.
Okay, sir. Okay. Just a minute. I think she got disconnected. Just a minute. Yes, Apsara, over to you. Apsara, you can hear us?
Yes, ma'am. Yes, ma'am.
Okay.
A very pleasant morning to all the intellectual, honorable guests, and my respected teachers. On behalf of KLE Societies, KLE College of Law, Navi Mumbai, I, Apsara Menon, welcome you all. It gives me immense pleasure to say that our esteemed college is starting with its 9th National Webinar Series. I will be hosting today's session along with Professor Pooja Bijargi ma'am, who will be moderating the event. Our guest speaker for today's section, Dr. Khumtiya Debbarma ma'am, has joined with us. We welcome you, ma'am. Today, ma'am will be enlightening us on the topic sexual harassment in the light of Constitution of India and other laws and analysis. Now, I would like to request our respected principal, sir, Professor Dinkar Gide, sir, to formally open the 9th National Webinar Series. Over to you, sir.
Thank you, Apsara. First and foremost thing, I would like to welcome our guest, Dr. Khumtiya Debbarma, who happens to be a very good friend of mine and alumnus of National Law School. We were batchmates, classmates, and then very hardworking and intelligent student, and very focused as she is always. And I'm happy that she has accepted our invitation. Thank you, ma'am, for joining us. I welcome you on behalf of KLE Society's KLE College of Law, Navi Mumbai. Thank you for that. Secondly, I would like to, as suggested by some of my seniors and researchers, there is a little bit of, the title with respect to sexual harassment. I would like to say that it must be prevention of sexual harassment in the light of Indian Constitution and other laws and analysis. So we say it to the participants, it is prevention of sexual harassment in the light of Indian Constitution and analysis. We forgot to mention that prevention word on flyer. We apologize for the same. Having said that, I am also very much happy that this is the 9th National Webinar Series. We are conducting it successfully since last 5 to 6 months. And I'm happy that we are going on a right track. Having said that, I would like to also, I'm also thankful to our management, Shri Dr. Prabhakar Koreji, who is a chairman of KLE Society, Shri Mahantesh Kavadgimat sir, who happens to be a GB chairman of KLE College of Law, Navi Mumbai, as well as he is MLC and Chief Whip Government of Karnataka, and Dr. Mallikarjunaya, who is our mentor. All the students of KLE Law College, all the teachers of KLE Law College, all the board and management and other members of KLE Society, all the participants across the country. Having said that, I'm very much happy, and I formally open this 9th National Webinar Series for further proceedings. Having said that, I would be joining all of you on YouTube. Thank you very much. And now I would like to hand over this session to Professor Pooja. Pooja, over to you.
Thank you so much, Principal Sir. A very good morning to all the participants. With immense pleasure, I would like to introduce the guest speaker for today, Dr. Khumtiya Debbarma ma'am. Ma'am has completed her BA LLB from Government Law College, Tripura, LLM from NLSIU, Bangalore. Ma'am has earned her doctorate from Tripura University. Ma'am has participated in numerous national and international seminars, conferences, and workshops. Ma'am has also contributed a number of articles for various reputed journals and chapters in the books. Ma'am has been an important person for 3 international projects as convener, lead researcher, and focal person. Ma'am has been invited for radio talks on All India Radio for discussion on various relevant social issues. Ma'am has worked as lecturer in Government Law College, Tripura, Tripura University, and IFAI University. Currently, ma'am is working as assistant professor in Manipur University. A very warm welcome, ma'am, and thank you for accepting our invitation. The session is over to you, ma'am. Over to you.
A very warm greetings from Manipur University and the alumni of National Law School, Bangalore. I first of all thanked our principal, Professor Dinkar Giti, who is my classmate in LLM National Law School, Bangalore, for inviting me as a guest today, or the speaker for today, and for bringing all the alumni together. I'm very proud of you to see you as a principal of the Law College, and at least I can be strong enough that my classmate is a principal in your college. I also thanked faculty coordinator, Dr. Amrita Singh, and Pooja Bizari, the coordinator of the faculty, and the student convener, Apsara Menant and Tejasri Sagvekar, and all the organizing team who has made this event successful. And also I extend my warm greetings to all the audience across India who will be listening today. As you already know the topic is relating to sexual harassment in the light of Constitution of India and other laws and analysis. Why I choose the topic, the agenda behind is basically an awareness. My ambit of my presentations would rely only on the act called the Sexual Harassment of Women at Workplace Preventions, Prohibitions and Redressal Act 2013. In order to interpret this act, I will go through the historical background of how this act came to be. And in highlighting the history about it, I will speak about Vishaka versus state of Rajasthan, and about the Iron Lady, Banwari Devi from Rajasthan, who has been the Iron Lady and who has been the main root of how this sexual harassment act came about in 2013. Can you please share the slides?
Sure, ma'am. Sure. I'll do that. Is this slide visible, ma'am?
Yes, it is visible.
Shall I move to the second slide, ma'am?
Yes.
Okay.
The first slide shows about Vishaka and others versus state of Rajasthan. This case was filed by an NGO called Vishaka and other women activists as a PIL in a Supreme Court to enforce the fundamental rights of the citizens, which is enshrined in the Constitution of India, that is Article 14, 19, 21, 15 of the Constitutions. Article 14 talks about equality of everyone irrespective of gender, caste, class, and 19 talk about freedom of expressions, right to follow any professions. 21 talks about right to life with dignity. 15 talks about right against discrimination. This particular case is a very landmark judgment in India because it deals for the first time relating to the safety of women at workplace. No other cases ever before has entered the Supreme Court, and hence the Supreme Court, in order to protect the woman at workplace, has laid down certain guidelines to be followed strictly by all the institutions, whether formal, informal, organized, unorganized, government or non-government organizations. Next slide, ma'am. Can you go to next slide, ma'am? Yes. what is the matter about why Vishaka and other women activists has to file a case in the Supreme Court? What is it necessary that a woman activist and organization has to file PIL in the Supreme Court? Let's go back to the year 1985. In this year, there is a government project for a woman in the state of Rajasthan where Banwari Devi was working as a social worker to stop child marriages and encourage children for educations, and she works for the welfare of the children in her particular district. But it is sad to know that during her work in 1992, she was gang raped. The main reason of gang rape is because she have insisted a family who has organized 1-year-old baby for a marriage. She have insisted father, but after she insisted the family not to give in marriage, she has complained it to the police, and later on to revenge her. Can you go to next slide, ma'am? Next slide. Since she has reported to the police, insisted several times, the family of 1-year-old baby and as well as a community have rebelled against her, ostracized her from the community. She was not allowed to fetch water from the commonwealth. She was not allowed to walk in the same road. She was isolated from the whole community. And therefore, to take revenge to her, 5 men of the Gujar community in Rajasthan has raped her. One among the 5 is the father of the 5-year-old baby who has raped her. She didn't get any support neither from the police nor the doctor where she approached her help for the first time. She didn't get any treatment. She got very bad treatment, and the police and the judges all said that how can a higher class ever raped a lower class lady? That was the answer from the police and the court systems. But irrespective of that, she was insisted to fight for her justice, lodge a complaint against, and since she was not supported with supported evidence because there was no support from the police and medical side, there was injustice happened to her. She did not get any justice, and hence this 5 perpetrators were acquitted by the court. Hearing about her case in Rajasthan, the civil society and the women activists went off to intervene, hear about her story, and raise her voice through various organizations in India and file a PIL in Supreme Court. Next page, ma'am. Yes, when it went to Supreme Court, the main idea for the petitioner is to intervene and support the woman at the workplace and implement the constitutional right of the woman to be protected. And here the Supreme Court, seeing the facts of the case, when there is substantial evidence and going through her Banwari Devi's case, found that India has been signatory to Convention on Elimination of All Forms of Discrimination Against Women, which is an international convention, and India has signed it in 1980. And secondly, it has ratified on 25th June 1992. And the Supreme Court says that since we have implemented, signed it, we have all the responsibility to implement this convention in our country and strengthened it through our Constitution of India through Article 14, 15, 19, and 21. Can you go to next place, ma'am? So Article 14, as I have said, right to equality, right to equality, and 15 says about right to be not to be discriminated, and 19 speaks about to follow any professions, 21 talked about right to life with dignity. All these article to be laid down strictly by all the institutions, whether private or public, government or any unorganized sector, for the safety of women at all workplace. Next page, ma'am. So the next slide talks about Vishaka Guidelines 1997. The guidelines came about in 1997. These guidelines has been the most important, powerful tool for the woman to seek justice for a woman in India. And this judgment has been law, and it has used the Article 141 of the Constitutions, where it says that all laws said by Supreme Court is binding to the law, all courts. So in fact, all whatever the guidelines is laid down in the Vishaka guidelines is equally should be equally implemented in whole of India and followed strictly in all the organization for the safety of the woman. In these guidelines, I will share about the definitions, what it really means sexual harassment of women at workplace. Firstly, it speaks about the physical sexual contact, sexual favors, sexual remarks, pornographic contents, and also verbal and non-verbal conduct of sexual in nature. Here, physical sexual contact means any physically you want to urge a woman without her consent. And secondly, the sexual favor, which happens in any of the offices, private or anything. I will give you advances and I will give you promotions. Sexual remark, whether in written or in verbal, whether in SMS or WhatsApp, these are defined as sexual remarks. And pornography, any dirty pictures or relating to any sexual abuses sent, and any remarks, and it includes a verbal and non-verbal as well. Next, can you go to next slides? So in the next slides, it says that the sexual harassment guidelines should be appropriately maintained and followed in all the appropriate authorities and organizations, both at private and non-private, and the institutions should take appropriate mechanism to redress any of the case coming as a complaint in their institutions. And it also says that any institution should have the internal committee, and if there is no organized or unorganized organization, there should be a local committee set up in the area or at a district level. And the complaint committee should be headed by a senior woman. And secondly, half of its member should be a woman. And further, the third party, either NGO or other people who are familiar with the sexual harassment issue should be a member. Here, why it speaks about NGO and other familiar with sexual harassment issue is that in an office, if you make a committee and if the committee belongs only to office, there might be chances that they will create any abuse of power and biasness towards the victims or other respondents. So NGO involvement and people familiar or the social worker who is involved with sexual harassment should be a part of the committee in any of the organized or unorganized institute. And can you go to next slide? The next slide talks about preventive measures. It is the sole responsibility of the employer or who's the head of the institutions to prevent sexual harassment and workplace in an appropriate manner. They should notify, publish, circulate the definition of what really is meant as sexual harassment in an appropriate manner in their respective office. And once the complaints comes, the victim or the witness or witnesses should not be victimized in their own office. If anything happens of that sort, the employer or the committee has to take a disciplinary action as per the norms and guidelines of Vishaka guidelines. And can you go next page, ma'am? Here, it speaks about the third-party harassment. Here, the third-party harassment talks about the perpetrator or the respondent who has done sexual harassment to a woman who's working in an office, whether organized or unorganized sector. Here, the committee, the internal committee or the local committee at a district level has equal responsibility to women to assist for her justice and give relief as well. And most importantly, the perpetrator need not be a member of the particular office. And as you have seen in the case of Vishaka versus State of Others, the Banwari Devi was raped not from the office persons, but she was raped in the process of her doing a work. And for a woman, while she goes to the office, in a way, if she get raped, it is equally important for the employer or the internal committee to help equally for the woman to seek justice. And hence, any women who are victims of the sexual harassment have equal right to seek justice in a criminal court as well as in civil court. And some of the important provisions which I'm going to mention from IPC is Section 294, Section 354, and Section 509. These three sections are very important for the Sexual Harassment Act. Well, I will just read you because some of you might not be a law background. So what the Act says. First, Section 294 says, thus any obscene act in any public places or sings, recites, and utters any obscene songs, ballads, or words, or in near any public space shall be punished with imprisonment of either description for a term that may extend to 3 months or with fine or with both. Section 354 of IPC talks about whoever assaults or uses criminal forces or any woman intending to outrage her modesty or knowing it likely that he will thereby outrage her modesty shall be punished with imprisonment for a term which may extend to 2 years or fined or with both. The next section, 509 of IPC, talks about words, gestures, or acts intended to insult the modesty of a woman. So these three acts specifically mentioned that any persons, whether belonging to the office or on the way, will be a culprit if he does any of the things, and it will attract this particular IPC sections, that is Indian Penal Code. Can you go to next slide, ma'am? And in the next slide, you have seen the Indecent Representation of Women Prohibition Act 1987. This act talked about the women indecent representations. It will equally attract, the Sexual Harassment Act equally attracts this law, and the perpetrator is also punished under this law. And other civil cases, the victim can also file a suit under law of tort because like she has lost her income, employment caused by sexual harassment, mental anguish, physical harassment, loss of income and employment caused by sexual harassment. So she is entitled to seek all the compensation because of this harassment caused to her under civil case. Can you go to next slides? So I'm going to next slides, talks about sexual harassment of women at workplace, Preventions, Prohibitions and Redressal Act 2013. We have previously talked about the history of how this act came about. And now we have the strong tools or the weapon which is regularized and put in a particular act where a woman can seek justice. And yes, it took about 17 years to have this law since 1997, which was filed by Vishaka and her group in Supreme Court, SPIL. And of course, there are similarities of the Vishaka guidelines and 2013 Act. And 2013 gives a wider aspects and wider horizon for the protection of sexual harassment of the woman. Firstly, the code conduct of the workplace is similar. What has been similar there of, like, for example, Interior Complaint Committee and the Area Complaint Committee at a district level. In Vishaka guidelines also, you have seen that each office have to have an internal committee set up, and when there is no office as such in a local community, there should be an area complaint committee at a district level where a woman will have an opportunity to have a complaint and seek for justice. And hence, as I have said, it gives abundant protections for a woman under this act. Can you go to the next page, ma'am? So let me just say you about how it came about, who's the person first introducing it. Without saying this, I think we are not acknowledging the ministers and the social workers who has been behind the door of this act. Firstly, it has been introduced by Child Development Minister Krishna Tirak in the year 2007, and it has been approved by the Cabinet in January 2017. It has been tabled by the Lok Sabha in December 2010 and observed by the Parliamentary Commission on Human Resource Development, and it has been printed out in 2011. In 2012, there is a minor change of the Vishaka guidelines to strengthen more further by including the domestic worker or the helper who's working at a household to seek justice. And finally, after the final print, it has elapsed into Rajya Sabha in 2013 and got the assent of the President of India in 2013 and finally came to an act in 2013 December. So this is how we got the particular act, Sexual Harassment of Women at Workplace, Preventions, Prohibitions and Redressal Act 2013. Can you go to next page, ma'am? So I will again highlight you about the important provisions of the Act. As I've said to you, the main aim of this presentation is basically an awareness. Firstly, again, we will go through it. There's certain, again, little changes of the definitions of what has been written in Vishaka and the present Act, but of course, mostly are similar. Firstly, it's talked about physical contact and advances. And I have said advances is about giving advances and taking undue advantage of a woman to do certain sexual in natures, a demand or a request for sexual favors, making sexually colored remarks, showing pornography, any other unwelcome physical, verbal, or non-verbal conduct of sexual nature. Here in this act, as I've said, the maid working in private homes is also included. In earlier case, in Vishaka guidelines, the maid helpers in the household were not included. And here they have extended the person who can seek justice, the woman were working. It can be a nurses in any hospitals or homes who has been working as a nurse, or a student in any educational institutions, a researcher, or a purchaser of things. It has also extended to customers, because the shop is holding certain services and giving to, selling it to the customer, and it has extended to the service taker also. And it is very important to note that the law does not include male workers. It is particularly for a woman. Can you go to next page? The next slide talks about complaint and conciliations. See, once any incidence of sexual harassment takes place to any woman who's working, what she has to do. Within 3 months of the incident, the particular person has to complain to the committee. If she is working in an office and there is an internal committee set up, she has to complain it to the internal committee members in writing. And if there is no internal committee member set up in any of the offices, she has to approach the local committee at a district level about her harassment in writing. In case the woman do not know how to write it, or because of some incident that she cannot write it, her legal heirs or a person has an equal responsibility to assist her and write for her. And once the complaint reached the internal committee or the local committee, complaint committee, the committee member has to research on it and see the circumstances of how it has happened and write a report and find it what has really happened. And after knowing the fact and knowing the truth of it, it is possible for the committee, internal committee as well as local committee, to have a justice in a process of conciliations without a court, and to settle the cases within the committee itself is well and good. And once it is not, it cannot be settled with reconciliations process or the conciliations process, it has to be transferred to the court. In the court, the magistrate, metropolitan magistrate or the magistrate of the first class have the authority, all the authority to try these cases and not below the metropolitan or the chief justice magistrate of the first class. Can you try? Can you go to next slide, ma'am? Next slide talks about inquiry into the complaint. Yes, inquiry into the complaint, it means once the complaint has come to the internal committee as well as a local committee, the committee have all the responsibility to inquire the matters. And as I've said, if it is regarding to domestic workers, the domestic workers, obviously at home, there is no internal committee. The domestic worker has to go to the local committee, and the local committee at the district level, if it sees that there is a prima facie case exists, that means if there is sufficient fact enough that some incidents has been committed or atrocities to her or a sexual harassment has been committed towards the woman within 7 days of the commission of the offense or the complaint, has to report a complaint to the police stations under 509 of IPC. And again, once it reached the court, the civil court, the court has all the power of civil procedure, that is in summoning, enforcing of attendance, examining, requiring the discovery, production of the document, or any other. The court has all the power. All the inquiry, whether in the court or in the internal committee or the local committee, has to be finished up, wrap up within 90 days, and the woman or the victim of sexual harassment should get justice within after 90 days. Means 90 days is the deadline for the inquiry, completion of the inquiry into the complaint. Can you go to next slide, ma'am? Next is action during pendency of the inquiry. Of course, what has to be done with the victim or the aggrieved woman in a particular office? Of course, there will be some social stigma in the society as well as in the offices where the offense has been committed. So in order to avoid all the circumstances, it is the act says about to transfer either the aggrieved woman or the respondents to another office where related to, and or the next speaks about to give 3 months leave to a victim of sexual harassment and any other reliefs that matters to the woman to give her. And the next one talk about punishment for false or malicious complaint and false evidence. Yes, the first one talks about complaint knowing it to be false. It is obvious that some people might take advantage of this act. And once the complaint is made in the internal committee or the local community, and after inquiry, it finds that the complaint is false, there is always penalty for people or a woman or a person who has made such complaint. And after that, when the complaint might be genuine or not genuine, the false evidence or the misleading document or any other such to prove that something has happened and all this evidence has been false, there is also penalty for such persons who has committed such act under the law, and the court will determine the punishment of it. And next, can you go to next slide? Next slide talks about determination of compensations. See, it is obvious that something has been happened to a woman in a workplace, and how the quantum of compensation should be given to the victim or the aggrieved woman. And considering all these, the Act have said that mental trauma should be considered, pain, suffering, emotional distress, loss in career opportunity due to incident of sexual harassment, medical expenses incurred for physical and psychiatric expenses, income and financial status of the respondent, that is a victim, woman, feasibility of such payment in lump sum or installment to the victim. So next slides. Next slides talks about prohibitions of publications or making known content of complaint and inquiry proceedings. So it is responsibility of all the employers in organized and unorganized sectors to publish press in media about the definition of sexual harassment and the guidelines involved, the penalty for sexual harassment at workplace, and to publicize about this Act 2013 on sexual harassment of women at workplace. And it is obvious that there is always penalty for people who's not following the guidelines. And next, it talks about the appeal. See, appeal, it talks about the internal committee and the local committee of at the district level. Once any victim or the perpetrator did not find justice while giving her complaint in the internal or local level, or there is no implementations of the recommendations made at the internal committee or the local committee, the person aggrieved of such recommendation or justice can go to the higher level authority to seek for justice. If the complaint has been made in the internal committee, the woman did not find justice or the recommendation has not been made, can go to the higher authority, that is the court, and that is the first class magistrate or the metropolitan magistrate or the High Court, or even can go to the Supreme Court. The next one says about the report. Each office, whether organized or unorganized, public sector or non-public sector, has all the responsibility to keep all the report of sexual harassment and make it a secret one, not to reveal the identity of a victim. And next one, it talks about appropriate government to monitor, maintain data. It is a sole responsibility of the government to monitor and maintain the data of all the sexual harassment in a very appropriate manner, and measures to publicize the act. It is also the responsibility of the government and like-minded organizations and the employers to make aware of the act, to enhance the protection of women so that sexual harassment do not happen in future. And the penalty involves for non-compliance with a provision of the Act shall be punishable with fine up to 50,000. It is not about the perpetrator alone who shall be punished, but it is also for the officers who do not maintain the internal committee setups for setting up this committee and for not following the guidelines of this Act 2013. There is a penalty involved, that is 50,000 rupees. So all the organizations, whether formal, informal, unorganized sectors, has to set up internal committee, complaint committee, and as well as at the local district. So next, ma'am. So I end my presentation here, and thank you, and thank you very much for hearing patiently. So you're welcome for any questions. I'm happy to answer you from my side, if it is possible from my side.
Thank you so much, ma'am, for the wonderful presentation. The way you have explained about the case laws, the relevant provisions. Thank you so much, ma'am. Ma'am, with your permission,
Thank
can we
you.
take a few questions?
Yes, ma'am. Yes, most welcome.
Thank you, ma'am. Ma'am, the first question is from Shankar Rajadaksh. He is asking, since courts take years to decide the case, whether the act of Phulan Devi was justified in the view of justice hurried is justice buried. What are your views on this?
Yes, of course, when there is justice hurried without proper investigation, there is obvious that something is there behind, some agenda is there. So there should be some time in investigations of any case. Take time and work calmly, inquire into it, investigate, and let the court decide in a manner that is slowly and very calmly. So that is what the court should follow for any of the sexual harassment of any woman at workplace.
Thank you so much, ma'am. Ma'am, the next question is from one of the participants. He's asking, what police did in the recent Hyderabad case, was it justified, where we did not know whether those who were killed were the real culprits? What are your views on this, ma'am?
See, whenever incident take place, it is obvious that when people die, they are the real culprit or not. First, the matter has to be investigated, reported, and we cannot blame any traitor unless evidence is there, and proper inquiry has to be taken. So that is, we can assume anything at first place. So investigation is very essential for any matters.
Thank you, ma'am. And the next question is from Mrs. Sumitra. She is asking, ma'am, which is the competent authority to try the sexual harassment cases and its jurisdiction?
See, for jurisdictions, first we have seen in the Act, firstly, the jurisdictions will apply for the metropolitan magistrate, and the magistrate first class have all the jurisdictions to try this case once it is brought to the court. And if it is not brought to the court, it is the internal committee member in the institutions where the internal committee member has been set up, and it is the responsibility of the committee to inquire and reconcile, settle the cases in reconciliations manner. And once it is not done in a reconciliation manner, it can go to the court, and the metropolitan magistrate or the first class magistrate has all the jurisdiction to try this case. Yeah.
Thank you, ma'am.
Yes.
Ma'am, the next question is from Sapna Desai. She is asking, should companies offer anti-harassment or post training?
On force?
On post training or prevention of sexual harassment, any training on this particular aspect?
Yes, obviously. It has been, there is always penalty, as I've said in the last slide, 50,000 fine for any institutions who do not implement this act in any of the companies. See, the employer, the boss of any of the company or any institution have the sole responsibility. As soon as the institution has been set up, the committee has to be set up by a woman who should be the head. Half of it should be a woman, and one should be a third person. Third person is an NGO, in order that the institution cannot be biased or there will be an abuse of power. So it is obvious that all the companies should follow the guidelines and should publish what is sexual harassment, what the penalty involves, what is the guideline of the particular office, what is this act is saying in an appropriate manner. It has been written in this act also. They have sole responsibility to implement in their office, to make people aware and perform training day to day to sensitize the office people. Yeah.
Thank you, ma'am. The next question from the participant is, can sexual harassment cases be tried against someone who is of the same sex?
Same-sex, the act only cover about women, okay? And it has also given open-handed sexual harassment. Firstly, I've already said, this act talks about women only. But if the woman is also disturbing and trying to follow the sexual harassment, it will obviously cover so many of section of the IPC. And obviously she's a woman, something has been done to her, or there's no protection for male, but obviously can seek any law protections for seeking the justice in civil or court, or in IPC section in the criminal court. Yeah.
Thank you, ma'am. The next question is from Jyotirani Bhaisha. She's asking, is there any law regarding sexual harassment against minor girl with special reference to incest?
Yes, of course, IPC will attract, law of tort will attract, POSA will attract. So many laws are there regarding child. And child, obviously, child, here you talk about, I've also mentioned who are the people who can seek justice under the act. A person who is studying in an institute, in a school, colleges, as a researcher, she's a child, or have equal right to seek the justice under this law, sexual harassment, because she's also employed as students in the particular institutions, a research scholar who's a teenage college going students, who's a child also, and the school goer have equal right to seek justice under this act event. It has extended its horizon, not only including who's working in the offices, but as well as the students, and as well as the buyer of any goods. So that is it. Yeah, next.
Thank you, ma'am. The next question is, can a man file a sexual harassment case against a woman?
As I've said in the first presentation itself, it is, yes, of course, a male can always file a case against a woman, but this particular act gives protections for a woman exclusively, and it did not extend the horizon for the protection of men, but men obviously can file a sexual harassment case and will attract many of the laws as well. Yeah.
Thank you, ma'am. The next question is, the participant has asked, can I make a complaint about a fellow employee regarding any behavior that has taken place outside the workplace, which has no direct connection to our employment?
Yes, of course. As I've said in one of the, this is very important, and thanks for raising this question. And I want people to be aware of this incident also. See, it doesn't need the perpetrator, as I said in one of the slides, but the perpetrator or the respondents need not be from the office itself. Okay, while a person who's working in an office or studying in any institutions or buying some things in any of the shops, while going and coming in the process in the journey, has she has something has been committed of sexual in nature, she can have all the rights under this Act 2013. And suppose she's working in an office, she have all right to complain in the internal committee, give her complaint in writing, and the committee have all the responsibility to support her and get the justice. And I have mentioned about the third party atrocities. It means the third party perpetrator, sorry, it's not atrocity, third party perpetrator. And the act says about a third party means the perpetrator or the person who has committed a crime who's outside their office. The committee has all the responsibility to help the victim in writing the complaint. And if suppose the reconciliations or the conciliation process cannot be done in the committee, then forward it to the police station, and from police station it will go to the court, that is metropolitan magistrate or the metropolitan magistrate of the first class. They have all the jurisdiction to try the case. So I'll tell you about the case of Banwari Devi also. It is not the employer who has raped her. It is the community or the village people in the process of her duty while she's stopping the child marriages. So it is one I've said is a father of the 1-year-old baby who has gang raped her. So they are the perpetrator were not employed in the office. but it all covers under sexual harassment at workplace. Okay, next.
Thank you, ma'am. And with regard to the similar question, it has been asked, how can a person make sure that the inquiry committee would be fair? Or is there a possibility that the harasser could influence the committee also? How can that be ascertained?
Yes. Okay. Yes, it is very good question also. See, for that, the Act says the internal committee should consist of first woman, okay, headed by a woman who's of senior in age. Half of it should be a woman. And thirdly, should be an NGO. NGO is very important. And any other person who is aware of the issues, who has been working with the sexual harassment case. The third party includes, avoids, in order that any abuse of power in the committee should not take place or the biasness should not be committed. This third party should question, and they have all the responsibility to question in the committee to see whether biasness has been committed or the false evidence, false representation, witness has been done or not. Third party responsibility is always there to see that nothing injustice for the woman or biasness has been committed in the committee members. Yeah. Next question.
Okay, the next question is from a participant called Shankar. He's asking, when 3 months period for making complaint is given to women working in an organization, then why only 7 days period is given for a woman working as a domestic help? Ma'am, don't you feel that it is violating your articles 14, 15 and 21 of our constitution?
Okay. See, 7 days refer to, I've mentioned 7 days because here the complaint, I've said the complaint, whenever the incident takes place, within 3 months of the incident, the victim should complain it in the internal committee or the local committee. And once the complaint reach the local committee members, the local committee within 7 days of the receiving of the complaint in their office should report it to the police, and thereafter the case can be taken up in the court. So that is what I mean, 7 days. 7 days is fair enough, means the complaint has already reached the local committee. Okay, so the local committee without any delay has to report an FIR case in the police stations. Okay. Next, ma'am.
Thank you, ma'am. The next question is from a YouTube viewer, Mr. Mirza. He is asking, some education institution don't make or don't have internal committee, even after informing them about such incidents. So what can be done in these certain kind of institutions?
See, when there is no internal committee in any of the educational institutions or any institutions, you have all the right to say the institutions make one committee. Okay, when you say make one committee, it should not be verbally. It should be written, and one who submit a written application of setting up the internal copy should have a duplicate copy with herself or himself. And once they are not following it, you have to do the follow-up. And then again, you can go to the court that they are not following this process. And once the court give them legal notice and they are not following these guidelines of forming the committee, they are equally responsible, and they are penalized, as I've said, 50,000 rupees, or it might be extended. It depends on the court also. If they are not following, what type of punishment the institution can be. It can take away the license of educational institutions also. So this is very important for all the institutions. So you can play as a one role as a person to make aware that institutions who are not having any internal committee to set up a committee in writing. Once you say it with the mouth, it is not proper. It is good to give in an applications and put the application, do the follow-up. Once they are not setting up, go to the court. So that is the best thing to do. Yeah, next question, ma'am.
Thank you, ma'am. The next, the participant is asking, ma'am, is there any time limit within which the complaint must be filed?
Yes, there is always time limit. Once the incident occurs, within 3 months, it should complain. But however, due to some reason, it can extend the time, because maybe sometimes the woman is so severe, nobody knows it. Due to some genuine reason, it can extend the case more than 3 months also. Means a complaint can go beyond 3 months also. It depends on the severity of the case or anything, whichever is reasonable.
Thank you, ma'am. Ma'am, with your permission, can we take up one last question?
Yes, ma'am. Yes, I'm very happy, and I found the participants is responding to my presentation. So I'm very happy, and I hope this act get enlightened to all the participants.
Yes, ma'am. It is, ma'am. Truly. Ma'am, the question is, ma'am, what if the result that has been given or the report that has been made on by the committee, if the person is not satisfied with that report, what can be done in that cases?
In that case, the provision of appeal is always there. Okay, as I have said in one of the slide presentations, once you're not satisfied with the inquiry or the justice has not been made because of false evidence or something false witness, or when the inquiry is good, the recommendations made in the conciliation process or employer or the committee, it has been not implemented. The person, the victimized, has not been satisfied in any of the manner of the inquiry system, can obviously appeal to the higher authority. Once the inquiry is made by the internal committee or the local committee not being satisfied, he can go to the court. Okay, court for an appeal. He can go to the Supreme Court, till the Supreme Court as well. So you can see in Vishaka versus state of Rajasthan also, she have filed a case in her own state, Rajasthan. She has been denied of the justice, and even the court also have said that how can a higher caste can ever rape a lower caste. So there was no support from the doctor, police as well, and then the woman group came about, the activists all came about, and further they have filed a case and PIL has been filed in the Supreme Court. So that is a process where you can go further for an appeal when you are not satisfied with any of the inquiry or the recommendation or the implementation, or justice has not been met. So whether in the court or internal committee, so you can always go to the higher authority. Yes, ma'am. Any more question, ma'am? Hello?
Am I audible, ma'am?
Yes,
Hello?
ma'am, you're audible. Yes, ma'am.
Okay, ma'am. Yeah, thank you so much, ma'am, for these wonderful answers. The chat box is filled up with the questions, but due to the paucity of time, we are unable to take up further questions, ma'am. I would like to thank you on behalf of KLE College of Law, Navi Mumbai, for gracing this event, for giving your personal inputs, for sharing so many case laws and so many examples with our participants. I'm sure the participants have learned a lot, and it was a very interesting session, ma'am. Thank you so much, ma'am, for coming and
Thank
gracing
you
this
too.
event.
Yes. Thank you so much.
Thank you, ma'am. Now I would request Apsara to kindly propose the vote of thanks. Apsara, please
So please
unmute.
unmute yourself.
I'm thankful to have this opportunity to propose this vote of thanks on behalf of my honorable college, KLE Societies, KLE College of Law, Navi Mumbai, for this session. I extend my gratitude to Dr. Khumtiya ma'am for taking time from her busy schedule to honor this session with such an interesting and informative talk. We have learned a lot today. Thank you so much, ma'am. I would like to extend my gratitude to the respected members of KLE Society's KLE Management for their blessings. Dr. Prabhagar Kore sir, Chairman of KLE Society, Mr. Mahandesh Kavadimat sir, Governing Body Chairman, Chief Whip, MLC, Government of Karnataka. Dr. Mallikarjunaya sir, Principal, KLE Society's KLE Law College, Bangalore, and the Director, KLE Law Academy, Bangalore. A big vote of thanks to our respected principal, sir, Professor Dinkar Kite, sir, for giving us this chance to be present in such a wonderful session. My heartfelt gratitude to all my dear teachers for their constant support and guidance. Thank you all webinar team for making this session such a grand success. And last but not the least, to dear participants for being the most important part of our webinar. Thank you once again, one and all.
Thank you.
Thank you so much, ma'am. Thank you once again.
Thank you so much. I hope
Thank
I can contribute in future even.
Surely, ma'am. Definitely. Thank you, ma'am.
Thank you.
With this, we end the session.